Good morning. This is the second meeting of the Special Select Committee on the Sexual Offences Amendment Bill 2019. This is the first public hearing for this committee. I welcome those present to the second meeting and the first public hearing of the Special Select Committee on the Sexual Offences Amendment Bill 2019. This hearing is being broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I am Clarence Rambarat. Like all the other members of this committee, I'm a senator, and I want to invite the other members of the committee to introduce themselves. But before I do so, I want to indicate that for today's hearing, we have with us Senator Dr. Maria Dillon Ramey. Dr. Dillon Ramey is not a member of the committee, but the rules, the standing orders provides for any member of the Senate to attend with the permission of the committee to attend meetings and participate in meetings of the committee. And this committee took a decision that for the full participation of members of the Senate who may wish to attend from time to time, notwithstanding the fact that they are not members of the committee would be prepared to entertain that, and Senator Dillon Ramey will participate in today's hearing. I now invite the representatives from the three entities with us today to introduce themselves. We have representatives from the Children's Authority, the Trinidad and Tobago Prison Service, and the Trinidad and Tobago Police Service. So perhaps we can go in that order: Children's Authority, the Prison Service, and the Police Service. Oh, I didn't forget to introduce.
Good morning, Chair. My name is Hanif Benjamin, Chairman of the Children's Authority of Trinidad and Tobago. With me today, I have Ms. Charlene Chaganat, Legal Services Manager of the Children's Authority of Trinidad and Tobago.
Good morning, Chair. Good morning to the other members of the committee. I am Gerard Wilson, Commissioner of Prisons Acting, and with me this morning I have Mr. Gavin Ferret, Legal Officer in the Trinidad and Tobago Prison Service. Thank you.
Good morning, Chair, and other members of the committee. I am Harold Phillip, Acting Deputy Commissioner of Police, Crime and Support. With me, I have Senior Superintendent John Frederick of the Court and Process Branch. I have Ms. Aisha Corby, Manager of the Victim and Witness Support Unit. Acting Assistant Superintendent Claire Guy Allen from the Child Protection Unit, as well as Mr. Claude Murphy from the Criminal Records Office. Thanks.
Thank you very much. And I now invite the other members of the committee, starting on my immediate right, to introduce themselves.
Good morning. My name is Gerald Ramdeen, Senator and member of the committee.
Good morning. Anita Haynes, Senator, member of the committee.
Good morning. Alison West, member.
Good morning, and a warm welcome to all of you who have found the time to read us this morning. I'm Jennifer Batiste-Primers. I am a member of this committee.
Good morning, Dr. Vamadi Alsing, a member of this committee.
Good morning, Dr. Maria Dillon Ramey, Senator.
We also have support from the parliamentary staff in the form of the Secretariat. And I now invite opening remarks from the three entities, and we'll proceed in this order. The prisons, the Police Service, the Prison Service, and the Children's Authority.
Yes. Good morning once again. On behalf of the Trinidad and Tobago Police Service, we are very grateful to be here this morning to make our representation and our presentation with respect to the Sexual Offences Amendment Bill. Having read the bill, There are several provisions which certainly would assist the Trinidad and Tobago Police Service in monitoring sex offenders. And as an organization, we intend to do all that we are required to do to build the capacity and the competence to ensure that we enforce the provisions of this act, of this bill.
Thank you.
Morning, Chair. Morning, members again. My statement will be very brief. I'd just like to indicate that the Trinidad and Tobago Prison Service, as an arm of the protective services and the criminal justice system, in fact, is committed to the safety and security of all citizens. In that regard, I'm hoping that the Trinidad and Tobago Prison Service can make a meaningful contribution to this bill and hope that we add value to the discussion. Thank you.
Thank you.
Good morning, Chair, and to the other members. It gives me great pleasure to be here to represent the Children's Authority. As you know, our core mandate is that of care and protection, and given an opportunity to share our voice in terms of the Sexual Offences Amendment Bill, we are then happy to ensure that our children continue to be protected. I thank you.
Thank you very much. And I now invite Member Jennifer Baptiste-Primus to open the questions on behalf of the committee.
Thank you kindly, Mr. Chairman. And I would like to start with the Trinidad and Tobago Police Service and start with Acting DCP, Crime and Support, Mr. Harold Phillip, to put him on the hot seat early o'clock. But it's not a hot seat, don't worry. I read your comprehensive, the Trinidad and Tobago Police Service comprehensive response, and want to request clarification on two areas. Your response, your comments on section 35.2 and also 38. I will go to the more controversial one firstly, section 38. I have read the TTPS comments with regards to section 38 deals with the non-application of this law. This part shall not apply to a person who was a child at the time of the commission of a registrable offense. But the TTPS has recommended the inclusion of a child in the sexual offenses registry, and you did submit a justification. But what my question to you is, what is the experience in Trinidad and Tobago with regards to child offenders? And what would have been some of the other criteria that would have influenced the TTPS to make such a recommendation to this committee? Because one, recognize you can't really reduce everything in writing. What is Trinidad and Tobago experience?
Well, thanks. When the Trinidad and Tobago Police Service review incidents involving children, both under the Children's Act, especially under the Children's Act, we are of the view that given the increasing numbers of children who seem to be engaging in sexual offenses, we are of the view that it's very, very important that they be tracked and monitored, because even as there is rehabilitation and so on, it is very, very important to ensure that their parents are given responsibility under this bill to assist in ensuring that they comply with the law. So, by and large, we saw the merit in ensuring that children, the provision be made to ensure that children are also monitored under this bill.
So that you also, TTPS also spoke about juvenile offenders. What age group are you classifying here as juvenile offenders? Because when one hears the term child, immediately images of literal babies, 5-year-old, 6-year-old, 7-year-old, so that perhaps it would be useful to us if you could define in terms of the age classification of a juvenile offender.
Well, certainly we would have wanted to keep it with respect to the definition of a child, a person under the age of 18 years. Obviously, there are persons who are duly in capax, and certainly persons age 5 and so. In law, the law recognizes that they are not responsible for their conduct. So, by and large, anybody who the law recognizes culpable, are deemed culpable for committing their offenses and have committed offenses under the Children's Act and so on, we have the view that consideration should be given for them to be monitored.
All right, Chairman, I just have one last question with regards to Section 38. I don't know if my colleagues would want to raise any other question. Do you all have statistics? Because if you're making such a recommendation, the experience in Trinidad and Tobago ought to be, with the making of such a recommendation, it ought to be supported by some type of statistic. In the year 2018, we had approximately 10 juvenile offenders. In the year 2017, we had 8. So when in the year 2016, we had 5. So the trend shows an increase in the behavioral pattern of juvenile offenders presenting a problem within the society. Are there statistics lying anywhere?
Yes. I certainly requested statistics. I was still perusing them, but I do not want to present them at this point in time because I was seeking to ensure that the figures are accurate. So in the near future, I certainly would be able to present those figures.
Chairman, perhaps for this committee to embrace such perhaps a useful recommendation, the committee has to have a little bit more than what Mr. Harold Phillip has presented. I wonder whether or not Mr. Harold Phillip can give this committee the comfort that such statistics will be conveyed to this committee under confidential cover.
Mr. Phillip, are you in a position? This committee has to report back to the Senate by March 29th, 2019. Are you in a position to indicate when the committee may be able to get some of the data?
So certainly by next week Friday. So.
Okay.
So that,
yeah.
That's March the 8th, 2019. Senator West?
Yes, just a follow-up. Can I get the view of the Children's Authority on that suggestion, please?
Thank you, ma'am, for allowing me. It is important to note that for the period 2015 to 2018, the Life of the Children's Authority post a proclamation, there were over 14,000 cases, of which we had over 272 sexual abuse cases, which makes up roughly for about 30% or so. What we have found in our assessments is a serious overlap between victims vis-a-vis perpetrators. So what we have found is children who were once victims move in the realm of being a perpetrator. And so what we have been looking at is whether or not there's any real purpose to put them on the registry as opposed to what is already in place. For example, the court has oversight and can mandate through order oversight, as well as the probation department, and whether or not that would be sufficient to monitor the changes over time with children who may have been charged or flagged as a sexual offender.
Senator Haynes.
Thank you. Good morning again. Is it useful to say that they can be placed on a register but omitted from a public register, so that way you get the monitoring capabilities, or is that already taking place? That was to DCP Phillips.
Yes, certainly they should be placed on a register, but without public viewing of that register, public access.
Just, Chairman, permit me, just a follow-up, DCP Philip. I'm going back to juvenile, the age classification of a juvenile offender under age 18. So where is the cutoff point? Is it from being a teenager, 12? It's from 12 to 18. All right, Mr. Chairman, I would just like to move on to section 35 and to the TTPS recommendation at section 35.2. Section 35.2 of the bill states where a person who is required to be medically examined pursuant to subsection 1 does not consent to the medical exam, he may be medically examined without his consent. And the TTPS recommendation that there should be an inclusion of the words use of reasonable force. Help us to understand the circumstances under which this use of force reasonable force is being recommended. And for those of us who are not in the police service, what is reasonable force?
There are several pieces of legislation that, in fact, even under the Police Service Act, when the police is required to take measurements, photographs, as well as fingerprints, there's provision for us to use reasonable force. So, by and large, when we are required here to ensure that he be medically examined and to do so without his consent, in keeping with what other statutes said, we agreed that we should include the provision of reasonable force to assist in compliance.
And what is reasonable force?
Well, there's a definition in law for reasonable force. And certainly,
no, I just want you to help us. I'm not trying any entrapment here. We don't understand. We are not there when prisoners are being processed and what have you. So from my own understanding, and I'm sure for the other members of the committee, what is reasonable force?
Well, in this particular case here, for him to be medically examined, we would certainly, I gather that he should be restrained. He should be restrained to ensure that he be medically examined, but certainly it doesn't mean beating him or anything like that, but at least restraining him to ensure that he be examined.
So that,
because
well,
we need to remember that the provision is if he doesn't consent. Mm-hmm. And you are saying here that he may be medically examined without his consent. And if he doesn't consent, it means that he isn't voluntarily doing it. So we may have to restrain him to ensure that he's examined.
What does that mean? Tying him to a chair, putting on a straitjacket? I'm just trying to understand.
Well, certainly the circumstances would dictate, but I'm not saying, I wouldn't want to say what the circumstances, but all I'm saying is to restrain him to ensure that he be examined.
Chairman, DCP Philip is not. he's not being very helpful to me at this point in time. So I would give other members an opportunity to ask.
Morning, Mr. Phillip. The concept of the use of force in these circumstances is one that is a new concept to the Trinidad and Tobago Police Service for this particular type of circumstance, is it not?
Yes, certainly.
Right. And I think Mr. Wilson will confirm with me that in the prison service, there is a what they call an order that is done by the commissioner that dictates what is the use, how does a prison officer use force in particular circumstances with respect to the use of reasonable force. A general order. I was looking for the word general.
So it's called a use of force policy. Yes, right. We have one, yes.
Right. Now, Mr. Phillip, having regard to the fact that this is a new concept that is being introduced into our law for the use of force to take a medical sample, do you think that it would be useful for a policy to be put in place to guide police officers who are mandated to implement the provisions of this policy or this act as to how they are to use force in particular circumstances?
Certainly, sir.
Right. And do you suggest, as the representative of the Trinidad and Tobago Police Service, that policy is one that should be set out in the legislation so that police officers, and this applies to prison officers as well, would be guided? Because reasonable force, as we understand it, and as you understand it, Mr. Wilson will understand it, has to be dependent upon the circumstances of the particular case. It may be that you hold the person down with your hands in some case. If he resists, then you have to increase the amount of force. The reasonableness of the force is dependent upon the circumstances, which will depend upon the legality of it. Now, this type of legislation requires you to virtually commit a trespass on the person, but you are being given the lawful authority to do that by the legislation. I want you to indicate to us, because it's very important, do you think that that should form part of the legislation or subsidiary legislation that goes along with the legislation to guide your officers?
Well, I want to say that I have not really seen it within statute. I just, I see the terminology, but I have not, ever seen, reasonable. I've seen it defined in judgments, but I have not seen it defined in statutes. So
Why I suggest that, DCP, is because in the courts, almost on a very regular basis, you have this issue about whether force has been used and whether the force that has been used is reasonable. And where you have legislation that deals with the taking of a sample in these circumstances against the will of the person, one can foresee very easily that in almost every single case, you're going to come up with a situation where the person whose sample is going to be taken is going to allege that the force that was used upon them is unreasonable. I see Mr. Wilson and Mr. Fred is shaking their head because that is the usual circumstance in the prison. So I'm just saying, I would like to get your view and the view of Mr. Wilson as well, as whether you think it would be useful as a guide to put into the legislation as to how this force is to be used in the particular circumstances of this type of legislation, because this is something new. Or do you think that it is better to leave it to the discretion of the officers, which history has shown is not really a very useful strategy in terms of leaving that very vivid concept of reasonable force to each officer in every particular circumstance?
Any clarification certainly would help, but as I said, I have not seen it defined previously in statutes, and I also believe too that given the punishment for failing to do so, that too may also act as an incentive for a person to ensure that they consent. So any help would certainly do.
Well, Senator, you would know, given our history, that there's a very thin line between use of force and abuse of force. So we are more or less experts on the matter. Sometimes officers may get carried away in doing something, especially if they're attacked. So what is the right use of force in these circumstances? Because I sat here and I listened, and in my mind, I was wondering where probably a blood sample has to be taken, what type of force could we use? Because in cases like that, if the particular inmate, in my instance, decides to get aggressive, everything could more or less fall down there. So I sat here listening, and I was wondering, how do we meet that middle ground between the use of force and abuse? So that, for me, if the person is in our jurisdiction, what I may try to do is use coercive methods, right? Very creative ones, to see if we could get the sample done. Other than that, we would have to use the type of officer, probably as mature enough to get the job done. So that is the only thing I can say, is using the right officers to get it done, rather than use officers that I may deem maybe a little more aggressive. So that is the only middle ground I could come to terms with in terms of this particular matter.
Well, to put it in our terms, Mr., you wouldn't be calling in the ERU to do something like this. Right, but Mr. Wilson, that leads us to another important question. This particular piece of legislation requires a great degree of input by your officers. What has been the degree of training that has been carried out by the prison service in order to prepare itself and its officers in relation to implementing this piece of legislation? And let me focus more particularly on, let's take, for example, this part about taking the samples. Now, obviously, the conditions that you have at one of your stations like MSP is going to be different from what you have at Port of Spain, what you have at Carrera, or what you might have at Golden Grove. So is it that, I would like to first hear from you, what are the preparatory steps that have been taken by the prison service to put itself in a position to implement the legislation, and then I'll take it from there.
Okay, sir. Let me say, I don't want to boast too much, but I would say we have a fantastic paramedic team, right? And they have a very good relationship with all the RHAs. In fact, I am very impressed at times when we run into situations, if we have something that we deem very serious, outbreak of whatever disease it might be, we get that cooperation from the RHAs, and I'm really impressed with that. So that we have started to discuss it, but we haven't started the training as yet to get it done. But we have discussed it. We know that it's coming, and I am satisfied that we have the right personnel to deal with this particular issue. I feel so.
Are you proposing, Mr. Wilson, and I'd ask DCP as well, are you proposing in the prison service to have a special unit that is designed with special officers who are able to do the implementation of, like, for example, the taking of samples? Not every officer is going to be able to be trained in the taking of samples or in the interaction with an inmate for this purpose of the implementation of the act. Do you propose to set up a special unit or a special team that is able to do that?
Right. Well, the only persons would be eligible to do that would be the paramedic officers, right? The infirmary staff. And as I said before, I think they are quite qualified and dedicated staff to do that. So I would just use the infirmary officers. In a case where the inmate becomes aggressive, then I would use the normal officer. But at first, I would use the cadre of officers who would be qualified to take the samples, which would be the paramedics. And their way of dealing with inmates is quite different to the normal officer. So I can say I already have those officers with that type of training and personality there for me to use. It's just a matter of harnessing this and getting it done, and probably having some workshops so that we could get the kind of expertise and for them to understand a little more what they are dealing with. So I would take it from that perspective, but it hasn't started yet, but it has been discussed.
And can you, because it's important for us to understand, can you, without fleshing it out in a shopping list for us, when you read this piece of legislation, can you help the committee by telling us what are the things that the prison service needs in terms of being able, just like how you said, like workshops,
Yes.
specialist persons to help you understand.
Yes.
We discussed the use of force.
Yes.
Can you tell us, so that we could make those recommendations through the committee, what are the things that you require as of now to be able to put your officers in a position to effectively implement this kind of legislation?
All right. Well, I'm happy I brought along the legal officer, because reading it, some of it, of course, would be, sort of. So Mr. Ferret will be able to explain more. Thanks.
Good morning to the committee. Good morning, Chairman. Gavin Ferret, Legal Officer, Trinidad and Tobago Prison Service. Well, having read the legislation, this particular section, the 35(2), I wasn't sure whether the jurisdiction would have fell on the prison service to actually take the sample, because to me it seemed to be a more police function, according to where the inmate falls, whether he's a remanded inmate or a convicted inmate. So it wasn't clear to me whether we had jurisdiction to take the sample at all, or whether we have to call in the police to take the sample. So it was not clear about that. But in terms of the legislation as a whole, the prison service is ready to engage the implementation of this act and cooperate with the police in that regard. So I don't think there's anything else for us. I think we have the resources there to treat with the legislation thus far.
If these samples, if and when these samples have to be taken at your different stations, Mr. Wilson, do you have the actual equipment, the actual infrastructure to be able to preserve an intimate sample that is taken at your station and to keep it safely until that sample can be transferred to a place where it has to be stored, tested, and analyzed at present?
Right. Well, I can't say for sure, but one thing I can say is that we will consult, because we have about 3 doctors, 3 PMOs, prison medical officers, so I could probably consult with them and see if we have everything in order, without having any problems as we go on.
The only reason we're asking these questions, Mr. Wilson, is that we want to be sure that when, as a committee, we report back, if there are any things that need to be put in place. We don't want the legislation to be passed and proclaimed, and then we hear the prison service needs this, or the prison service needs that, or an inmate needs to be examined and things are not there. So we just want to find and make sure that we're in a state of readiness. That's why we're asking these questions.
Certainly, sir. So what I'll do, as soon as we are finished, I'll check and I'll get that report back to you as soon as possible.
Much obliged.
Thank you very much.
Thank you very much. I now invite Member Dylan Remy.
Good morning. The question goes to the police service, the person representing the police service. The reason being, usually when someone is held, charged, you are the first persons to be there at the time when that sample, because it's supposed to be taken at my understanding is at the time, like if you have a situation or the case of suspected rape, etc., it's usually done at the time the person is held. Would you have usually my understanding too is that this is done by the district medical officer or medical officer representing the county medical officer of health's office. How do you see your members being able to carry out this particular part of the legislation?
Well, the law provides for taking intimate and non-intimate samples. Intimate samples are in fact taken by medically qualified persons. Non-intimate samples, provision is made for police officers to take non-intimate samples. In the police service, we have crime scene officers, persons who are trained to deal with evidence recovery and so on, and evidence gathering. And they are the ones who, in fact, are responsible for taking non-intimate samples in the Trinidad and Tobago Police Service.
So, therefore, once the person has been arrested and be charged, you are saying that the medical officers will be the ones doing the intimate samples?
Yes, the medical, yes.
So therefore, the issue will only arise with you, your team, if you have to be using force.
Yes, that's what non-intimate samples.
No, for
generally?
intimate samples, if an intimate sample is to be collected and the person refuses, that's the only reason at that point in time that your officers are going to be required to act?
Well, in this particular bill here, it spoke with respect to that aspect of being medically examined, for that sample to be taken, right? So it's in that context we said the use of force when the sample is to be taken without reasonable force, without the consent of the person.
Thank you very much. Member Baptiste Primus, and then, okay, Member Dial Singh, and then Member Baptiste Primus.
Morning. I would just like some clarification. Usually, if there is a victim, like a rape victim, that victim will go to the DMO, as Senator Remy mentioned, and the evidence for court and the whole procedure it falls under the ambit of the district medical officer. Is your prison medical officer also, given that authority, if he takes that sample from the accused, to have that advantage of also going to court like a district medical officer? Is he trained into that procedure?
Through the chair, as far as I'm aware, the prison medical officer is also a district medical officer, and I believe that he would also have those similar powers.
Thank you kindly, Mr. Chairman. My question is a follow-up question to Mr. Wilson. In your comments, on page 2 of your comments, you pointed out, let me say it was pointed out, that there's no provision in the bill to treat with the instance where a person is charged with a registerable offense is in prison custody. And in such a case, it would have to be stated whose responsibility it is to enforce the order. Is it that you're saying that the Trinidad and Tobago Prison Service would be comforted if the legislation speaks directly to the prison service responsibility and the police service responsibility, so there's a demarcation line, what the prisoner is responsible for as against the police? Is it that you're saying the legislation must speak to that?
Through the chair, yes, we'll be comfortable with that. It would demarcate what the exact responsibilities are for the police service and for the prison service. So we would be happy with that if that is defined that way.
And Chairman, just as a follow-up, I would like to ask DCP Philip his views on what has been suggested, that enforceability of the order must be clearly spelled out in the legislation, who is responsible.
With respect to the order, we made a comment that it appeared a bit ambiguous. It appeared that we did not know who the order would have been directed to, if it's in particular to the police or medical officer. And we also, under the DNA Act, the Administration of Justice, the Oxyribonucleic Acid Act, they speak to the whole aspect of a notice whereby with respect to taking a sample, the police officer can serve a notice on the person for telling them, giving them a date and place as to where the sample, where that person has to come to give that sample. So we were saying that the order made by the court should be represented in the form of a notice to the police, thereby we serving it on the particular person, indicating where the person is required to go, if it's at a medical hospital, if it's at a hospital, a public institution, which, and given a time frame, if it's within 24 hours or within 48 hours, in order for that person to comply with the order. As well as probably even in the schedule, put in a specimen of what the order, the contents of the order.
Okay. Before I go to Member West and then Member Ramdeen, I want to say after those two members have made their contributions, I would like us to come to the Children's Authority to ask some specific questions on your submission, and then to the Prison Service to ask you specific questions on your submission. Particularly, you made a submission on the use of force. Senator Ramdeen has asked whether it should be detailed in the legislation, and I just want to get your views very clear on that. And then the Trinidad and Tobago Police Service, you've made a comprehensive submission identifying maybe 12 areas of the bill, and I just want to make sure that you have the opportunity to address all the areas in your submission. But before we come to that order, I would ask Senator West, followed by Senator Ramdeen.
Thank you, Chair. Chair, I'm directing this question to the Children's Authority and to the TTPS in particular. A significant issue that has been raised during the course of the debate on this bill is whether or not the register should be made public. What we are doing here is trying to find the right balance between protection of the rights of the perpetrator on the one hand and the victim and potential victims on the other hand. So in that regard, can I get the views of the Children's Authority and the TTPS in particular on where they stand on whether the register of sex offenders should in fact be made public?
Thank you, and through the chair. Just for clarity, are you speaking specifically to children or both children and adults?
With respect to the register, I would think the focus would be on adults because, as suggested by Senator Haynes's earlier question, I would think that if we decide to go the route of registering children, that we are probably likely to lean on the side of keeping that from the public.
The Children's Authority has no objection to the public publication of the registry for adults.
DCP Philip, can we get your views on that, please?
Well, certainly we would want to believe that it should be public, it should be made public to ensure that we could have the benefit of the public protecting themselves, having had the information about persons who are in fact registered sex offenders.
A concern has been raised on that score that if we do make this information public, that we are exposing perpetrators, former perpetrators, to the wrath of the public among which they live. What is your view on, what is the view of the TTPS on that score? Do you see that as a real risk? And is the TTPS prepared to address that risk?
Well, certainly it appeared to be an obvious, one of the risks that certainly would come to mind. But given when one is looking at safety, when one wants to balance, the general safety of the public, I think that would outweigh, that should outweigh that information being outside there to the public.
Senator Ramdeen.
Thank you, Chair. Mr. Wilson, you have the act before you there?
Yes.
Right. Can I ask you to look at section 35 for me, please? The new section 35(3), if you direct your mind to section 35, subsection 3, it says, where an examination conducted in accordance with subsection 1 or 2 reveals that the person examined is found to be suffering from a sexually transmitted infection, information to that effect shall be immediately communicated to, and I'm focusing on the person examined in relation to your responsibility. If that person is in custody, prison custody, at one of your prisons, how do you foresee this information being revealed to the person who is in custody, who is the person who was tested, who is going to, how is that information going to be transmitted? And why I'm asking you this is for this reason. A lot of what is revealed in this legislation is confidential information. We have a concern about people's personal information being revealed in circumstances where it breaches their right to privacy. There's a general concern. And I want to understand how this information, do you foresee this person being told that the results of the test has been so and so, and that information that is now in the custody of the prison service is going to be put or stored in some place that it is confidential to the person whose information is in your custody?
Okay, that is something that we deal with, apart from this legislation here. It's something we deal with on a daily basis because any medical information at all is confidential and is kept by the infirmary locked away so that once the inmate sees the doctor, of course the infirmary officer would be told because there would be medication to give the particular person. So that is very confidential. And then if there's an issue of informing that person that, look, this is what is happening, we also have the use of the prison welfare officers who would sit and counsel if necessary, if the news is not good news at all. So that the information is confidential, it is locked away, so nobody else knows. In fact, if from time to time we get requests about inmates and their health, and that would have to go to the prison medical officer in order for him to release that information. So it is kept, it is guarded, it is kept locked away, and it is confidential.
Give an example, Mr. Wilson.
Yes.
Our beaten case. The Attorney General's office is sued. They have to bring the prison inmates' file for them to get instructions. If this information is contained in the prison inmate's file, which is a general procedure,
yes.
Once instructions have to be given, you have to disclose the file to the lawyers.
Yes.
Is it that that information is going to be in that file so that any lawyer that has custody of that file, right, is going to see the position with respect to that inmate's confidential information with respect to his condition in these circumstances?
All right. If the information is specific, for instance, if whoever is asking for the information doesn't require that medical part, then we would withhold, or we are thinking that if we have to give this to a lawyer, that lawyer will be, credible enough to keep the information, But I think it's something that we have been, approached with from time to time, and we have to deal with it in a very sensitive way. So I'm thinking that if that information has to leave the prison, and it is just information, information that doesn't concern the medical history, we can probably withhold that and send the rest of the file, or copies of whatever is needed.
Yes, Mr. Ferret, you'll be able to probably answer it like this. Can I suggest that perhaps having regard to the way in which we are modernizing both the prison rules, your policy, the legislation that you have to implement, just like how you have a general use of force order, do you think that it would be useful for you to have a policy dealing with the confidentiality of personal information of this nature that comes into your custody, both perhaps for yourself and for the Trinidad and Tobago Police Service? So it's not treated as general information that puts into a prison inmate's file, and any welfare officer, any officer who dealing with the infirmary that has custody to those documents is able to have access to that kind of information. Because, Mr. Wilson, what we are guarding against here is simply this. When a person's personal information is released, there's no way of retrieving that situation. And we want to be sure that this type of personal information, this is not simply medical records where somebody's hand is broken or they get treatment. This is personal information. And that leads me to the second question. I'll give you an opportunity to answer that, but I want you to also consider this. When information comes into your possession that somebody is suffering from a sexually transmitted infection, do you have provisions that you exercise as the Commissioner of Prisons to take that person now that you have this information and put them in a special place at your different institutions so that they don't mix with the general population, whether it be in remand or whether it be convicted?
Right.
Because that is quite important for us as well.
Well, I'm happy you asked that question, Senator, because one of the things that we always speak about is the overcrowding situation. However, we try we have a duty of care to inmate and to officer, right? So one of the things we ensure is that we always have provisions for situations like that where we have to isolate, good? So that we have the infirmary, and if we have to move that person from one station, if there's not enough, if we can't isolate them where they are, we move them to another facility where they can be isolated. So there are provisions in cases where we have to isolate somebody based on what could be one of those diseases that could be communicable. So we have to move them away and put them in a different location. But there are provisions for that.
I want to just add to a question that Senator West had asked the DCP, which is this. Having taken those steps to isolate these specific persons who have been found to be having contracted a sexually transmitted infection,
yes.
What steps do you propose to put in place, Mr. Wilson, to protect those persons from inmates themselves? Because what happens is that, as you know, right, the experience is in the public domain. Where an offender offends against a child and they reach inside the prison, right, they are a target immediately. And it has happened before. I mean, we don't want to get into names or specific, but while one understands the manner in which inmates would feel about somebody who is accused or simply alleged of committing this type of offense against a child, you know, we have to be able to take steps to actually protect that alleged offender, to guarantee the right to presumption of innocence and to guarantee that person has a fair trial and they don't meet their faith when they come into your institution.
Yes.
That is no criticism of your officers. I'm talking about inmates.
Yes. Mm-hmm. Okay. Well, this is something that we have been dealing with for a long time. And I'm happy you asked the question because I would like to say that even inmates have a code of ethics, right? They have their own code of ethics. So any person coming in with those sexual offenses, sometimes depending on how much is highlighted in the newspaper, will depend on whether that person coming is popular or not. So we have a particular facility that we send those persons until sometimes they remain there for a year or two, until everything calms down, and then we bring them out. So from the time, in fact, as soon as an article comes in the newspaper about any offense that is heinous or any offense dealing with children and rape, even before they come into the system, we already find a suitable place to put them until all the drama, you know, calms itself. So we have been doing that for quite a while.
Very happy to hear that.
Yes, sir.
Okay, as I indicated before, we would engage the Children's Authority, and I intended to direct your attention to 3 areas. One was the issue of the publication of information contained in the registry, but you've responded to a question from Member West already on that. So the 2 remaining areas would be the proposed section 45(5)(d) of the bill makes provision for the Chief Immigration Officer to place a stamp in the passport of someone who is convicted of a sexual offense relating to children. So I wanted to get your views on that, because during the debate on the bill, there were different views expressed in the debate, and I wanted to get your view on that. And the second one is the issue of, this issue of that you referred to in one of your submissions of taking photos, fingerprints, and non-intimate samples forcibly from a child offender. So the 2 issues, that issue of taking photos, fingerprints, non-intimate samples, and the second issue is the issue of the introduction of a provision in the bill for a stamp to be placed by the Chief Immigration Officer in the passport of someone convicted of a sexual offense relating to children.
Thank you, Chair. In reference to the first of your questions, for us the question continues to remain whether this is for children and or adults. And if it's for children, what is the purpose? What is it going to solve or help with in terms of protection? When I read the bill, I saw the need, perhaps, or the rationale in terms of an adult moving through jurisdiction, whether it is for work purposes, engagement purposes, whatever it is. But in terms of children, I am yet to see the need and or the reasoning behind why it would be needed in a child's passport. And this is on the backdrop of the monitoring already in place through the courts, through the judges' rules, and the likes of. In reference to number 4 of our submission, which is taking photo, fingerprints of non-intimate sample forcibly of a child, we believe that the judges' rule for children 2016 adequately speaks to how that should be done and whether or not there should be a separation, again, between adults and how it is done for and with adult as opposed to children. Again, I am making this on the backdrop of where the statistics lie in terms of victim moving to perpetrator. And so we believe that when you look at the judge's rule, and even if we were to strengthen the judge's rule to include some of what we are discussing might be helpful as well. But we believe that the judge's rule adequately supplies and can guide us in relation to the taking of the photo fingerprints, etc.
Mr. Benjamin, before I invite members to maybe ask you any questions they wish, is there any other matter that has come up on this bill during the course of debate that you wish to address at this time?
Yes, Chair. Number 5 in our submission, which is the amendment to mandatory reporting, we believe that Section 31, brought about by the Children's Act 2012, come into play here. And the reason for this is we believe that the statistics have shown us, the evidence has shown us where too many of our children who are abused continues to remain in an abusive situation because of non-mandatory reporting. For example, whether it is mothers not reporting stepfathers or uncle, whether it is because of economic status or whatever is the situation. And so we would like for this committee to consider whether or not that Section 31 can be brought in here. And yes, and so I'm being advised that it is being considered, and so we are excited by that fact. Again, because of the statistics that we are seeing where our children are not getting the help that they need because of the lack of mandatory reporting.
Has the Children Authority addressed its mind to anything that exists right now where an adult in a position of trust in relation to a child? So, for example, a school teacher or a health worker should have a mandatory requirement to report matters of sexual abuse.
I will ask our legal services manager to address.
Good morning, Chair, members of the committee. So this is precisely the issue that the chairman is raising in relation to the question of mandatory reporting. In fact, Section 31 of the existing Sexual Offences Act, the unamended version, does contemplate persons in positions of trust, such as teachers, medical practitioners, and so on, and such frontline persons being in a position to be bound by the mandatory reporting provision. So what we are asking for, and having regard to the development in the law by virtue of the Children Act 2012, which now introduces a much broader range of sexual offenses that may be committed against children, our suggestion was that the mandatory reporting provisions also attach to all of those offenses.
Are there any members of... Right, thank you. Senator Ramdeen.
Mr. Benjamin, thank you for being here this morning. I want to ask you a few questions based on Section 26 of the Act, Mr. Benjamin. From the information, 26, from the information that you would have in your possession, that is the Children's Authority, do you accept that children generally mature at an earlier age now than in previous years before?
Thank you so much. You're asking a clinical question.
I know you're an expert in that area. That's what I'm asking.
And I'm wondering if it's under my remit as the chair of the Children's Authority to speak to whether or not children mature faster. I would preface that by saying that the environment, the social environment in which children are being brought up now is much different to that back then. And definitely the elements therein allows for children to be more exposed to a number of stimuli or stimulus from the environment. Okay. So to answer your question, I would say yes.
Okay, the reason why I'm asking you that, Mr. Benjamin, that Section 26 does a very, creates a very serious consequence of raising the age of Dolai Incapax from 7 years to 12 years. And therefore, by virtue of this piece of legislation, you have someone who is from 12 and under incapable of committing all of the offenses that are provided for under this Act, meaning the Sexual Offences Act, Parts 4, 6, and 8 of the Children's Act, and I have those provisions here, and Parts 16, 17, 18, and 19 of the Trafficking in Persons Act. Do you support the raising of that age of Dolai Incapax? And Ms. DCP, I want to ask you that same question having regard to your experience, your vast experience as a police officer.
The age, on what I'm being advised, has always been 12. For sexual, in relation to sexual offenses.
Well, that's not my understanding of the law. The law is, right, this is not only in relation to sexual offenses. These are new offenses that are created under the Children's Act and the Trafficking in Persons Act, and under the common law, right, which guides the position where it is not provided by statute. A child under the age of 12 can commit an offense, under the age of 7 cannot commit an offense in law. So that what I'm asking is, by virtue of this piece of legislation, we are taking a positive decision to raise that age from 7 to 12. And I want to find out whether the Children's Authority is in support of that position.
I will ask my legal services manager to give us a view on that.
Now, we are aware that the common law position in relation to the age of criminal responsibility for the commission of sexual offenses, yes, is 12. So that this, the amendment at Section 26 relates to certain parts of the Children Act, the parts that specifically relate to the sexual offenses. So we do not see it as a major inconsistency or development in the law per se.
Perhaps it would be best addressed by a further submission from the Children's Authority.
Yes.
Member Ramdeen has a particular view.
Yes.
And we would invite a further submission in writing from the Children's Authority on the issue. The police service, on that specific issue of the age.
Well, certainly internationally or overseas, the age seem to have, in terms of a person who is Dolai Incapax, seem to have risen, probably is closer to 12. And in light of that, there's no issue, we don't have an issue in terms of if the legislature wishes to increase the age.
Legislating, Mr. Philip, is about this. On a daily basis in our country, the types of offenses that are prescribed by these pieces of legislation are being committed by children younger and younger. The age of criminal responsibility is being raised to 12, but you have persons engaging in sexual activity under the age of 12, right? You have people who are becoming pregnant under the age of 12. And we are prescribing legislation that has to be implemented by Trinidad and Tobago Police Service, where we are saying someone who is below the age of 12 is incapable of committing these offenses. And I think it's a very important position for us to take as to whether we think we are protecting children, right, who are involved in criminal activity by prescribing an age that is too high to catch people who are, you have people 11 and a half engaging in sexual activity, and by this piece of legislation, you're telling me that the offenses for which we're talking about here, you know, the offenses, Mr. Philip, is child pornography, right? Other sexual offenses, I'm not going to list all of them, and offenses of female genital mutilation. Now, I have a difficulty in prescribing that persons who are actively able, the rule in Dolai Incapax is premised on the fact that below that age or of that age, a child cannot have the mental capability to know that what they're doing is wrong, and therefore the law provides for that. But I have a difficulty in prescribing that a child who's 12 years old, 11 and a half, 11 years, 11 and 3/4, we are saying that that child engaging in these kinds of activities, the criminal law will not catch them as being liable. We're giving a whole thing. I want to find out whether you think that that is more in the public interest or whether you think that it is something that we should consider again. That's all.
Thanks for that.
Philip, as I indicated to the Children's Authority, it is an important matter, and we'd give you the opportunity to make a further submission in writing. I want to now invite the prison service. You've already touched on your submission, really focuses on this issue of force, reasonable force. We've had some discussions on it, and I just want to ask you if there is anything further you want to say on that particular issue or any other issue contained in the bill.
Thank you, Chair. I just wanted to say that the fact that the prison service already has the use of force policy, I don't think putting it into legislation may make, a difference. So that I am thinking that we can work within the, that use of force policy, that we have to ensure that if we have to use force at all, it will be suitable force to get the job done, and of course we'll use coercive means, prior to any use of force at all. The legal officer, Mr. Ferret, indicated that there were 2 issues he wanted to raise based on the legislation. So I'll allow him, Chair, through you, for him to explain those 2 issues that he had.
Okay.
Through the Chair. There's a concern that I would have in terms of the examination of the VC. My view is that it should have been made compulsory for certain classes, because there may be good reason why we would not want to test each VC for a particular, to see if they are infected with a particular STI. But in this instance, the seriousness of this act, I believe that we could have tested in cases of adults, that at most times you should test all of them, both VC and both offender. There's just a suggestion that I would have had.
Member Ramdeen?
Yes. Mr. Ferret, just to understand, I understand what you're saying, but what is the rationale behind suggesting that we test all the VCs as well, in addition to the complainants? Sorry, in addition to the accused.
Well, what I would have thought is that if the perpetrator would have caught probably it might have been the VC who's the person that carrying the sexual transmitted disease, and we don't want a case where the offender may want to bring an action against the VC saying that I caught a disease from this person, I should not pay compensation. It's just in that regard. So I don't know if that was considered at all in
Member
any policy
Dianthi.
consideration.
Thank you.
Yeah. Chair, often when we are testing also for HIV, we also test the, we will test both partners, just to also ensure that, if there's any sort of allegation, which partner give it. So we tend to test both partners. So I could see the logic in that argument, because you may have a virtual complainant who may have had an illness before, based on certain, whatever, sort of activities you engaged with before. And in that way, I think it should be actually mandated that the virtual complainant also be tested. Yeah.
Okay. Thank you very much.
Just one last
Senator
comment
Dillon,
on that. It says may. The person does not, the only reason, my understanding, that this is being done is if that person who's a virtual complainant wants to claim compensation that that person has been affected by as a result of that offense. If there is no such complaint, or if there's no such action subsequently, what is the reason for wanting to test that person? Remember, that person is the complainant. That's not the person who is alleged to have perpetrated the act. Why, therefore, would you say that they should be tested?
But my thinking is that my thinking is on the point, is that the offender may want to bring a claim and say that I didn't contract, I was at a point in time clean and I would have contracted the disease from the VC. And that could be a plausible complaint by any offender going forward.
Okay, thank you. The Trinidad and Tobago Police Service, you have made a written submission, and you have covered in your submissions today much of what is in the written submission. So I want to ask you, you've made a submission relating to Schedules 2 and 3. If you would address that particular submission, and that is to, you've made recommendations relating to the place of employment, the photograph, and the email address, etc., of the convicted sex offender. So I want to ask you to make your submission on what you have in the written submission, and beyond that, I want to invite you to make any submission, whether it's contained in the written submission or any submission based on what has come out in the public domain on the debate on the bill we've had so far.
Yeah, thank you, Chair. But just before I go to Schedules 2 and 3, may I just address you on Schedule 1? There is on page 4 of the bill a definition for registrable offense, which means an offense listed in Schedule 1. And when we look at Schedule 1 on page 27 of the bill, we saw that an offense under A, the Sexual Offences Act, Chapter 11, 28. And on our first submission, we had a concern that when we look at the intent of the purpose of the sexual, having this registry, sexual offences registry, we were of the view that we wanted to focus directly on perpetrators, sexual offenders, and persons who are committing sexual acts or also encouraging and so on. But when we look at Section 32 of the Sexual Offences Act, it actually speaks to basically a person, persons who actually publish, who ought not to publish the names and ages of, be it the accused or the victims of the offense, and so on. And we were very mindful to request or to make a recommendation whether that particular offense should be excluded as a registrable offense. Because given, the very nature, the inherent nature of that type of offense, we didn't see that person as being a sexual, as a sexual offender.
Thank you very much for that submission. I believe Member Baptiste Primus has a question.
Thank you very kindly, Mr. Chairman. DCP Philip, on page 2 of your written comments, it is recommended that a registration program be implemented. Could you share a little more? Could you expand on that suggestion a little more, please?
On page 2? Yes. What
was the thinking behind
that was it? We were saying that that is in the giving a little backdrop to ensuring the registry. Speaking about the registry, that whole aspect of implementation of the registry is in fact a registration program. We were just putting some footnotes to our point, but it meant that we were speaking about the registry, the implementation of this sex offenders registry.
Okay. Senator Ramdin.
Mr. Philip. Mr. Philip.
Yes, sir.
Yeah, I want to thank you for that last submission that you made, because it raises a very important point. That same policy argument that you are raising with respect to the section, with respect to the publishing of information, right? That's section 32, right? And the fact that your reason, which carries a lot of weight, is that that doesn't really bite on the fact that that person should be registered as a sex offender. If you examine some of the other offenses, take, for example, section 55, section 54, would that same submission not apply mutatis mutandis to those types of offenses there, and perhaps require us to look again at this particular Sexual Offences Act? You see, these are the offenses that deal with the failure to disclose and the administration of the act. Somebody commits an offense. That doesn't really deem them to be, which is the policy, as I understand it, of what you are saying with respect to the publishing argument. It doesn't deem you to be a sexual offender, because you can commit an offense here that has nothing to do, for example, the confidentiality provision. Somebody who breaches the confidentiality provision is caught by this and will be liable to be put on the register. All I'm suggesting, Mr. Phillips, is that you made a good submission.
No, yes,
and perhaps we should look at the offenses again to see whether all of the offenses that are created by the Sexual Offences Act are offenses that we want, even the commission of which would be such that we would want to put that person's name on the sexual register.
Yes, and you are referring to some of the new offenses that have in fact been created.
Correct.
Certainly.
On the basis of what you said in relation to the publication.
Yes, because we have the view that the sex offenders registry is to track sexual offenders. The trust should be that, the purpose.
I think you have very, very useful and very important submission, Mr. Philip. Thank you for that.
Thank you very much. Mr. Philip, I would just, in closing, return you to Schedule 2 and 3 and ask if you have anything further to add on that.
No, I do not have anything further to add on that. However, I have 2 other points I would just want to add. They are not in the document.
To raise those
Certainly.
points
now. In the bill, they spoke about designated officer. And with respect to designated officer, they basically refer to, there's a definition there that speaks to a person who is the rank of sergeant and above. with respect to the police. However, given the provisions of what both the prison as well as the immigration officers, given the functions that they will have to perform, and I gather that there wasn't any room for delegation based on how the bill is written. So we were suggesting whether there may be the need for at those locations, those institutions also to have designated officers. Because when persons are coming into the airport, if somebody has to report the immigration, you wouldn't see the chief immigration officer at the airport. They would have an immigration officer.
Okay,
so,
I understand that submission.
Sorry, thanks. And there's under the mandatory reporting for 6 months. When we look at the timeline, we were of the view that if there are persons who are prevalent or persons who would have committed really serious and heinous offenses, is it that everyone must report every 6 months, or it should be left to the judge to make an order indicating, well, because you would have been a repeat offender, as the case is, you should be really reporting every month or every 2 months, as the case is. So we just had a concern about the mandatory 6 months and whether there could be some flexibility left to the judge or the magistrate for that consideration.
Right. I would now invite Member Haynes to ask the final question from the committee.
Thank you, Chairman. We had Senator Ramdeen ask the prison service about the readiness and how we can help and the question was posed to TTPS, but I don't think you ever got the chance to answer in terms of what would the TTPS need to effectively enact this piece of legislation, and I think...
Well, thanks for the question. Given the provisions of the previous Sexual Offences Act, we had initially embarked upon establishing a sex offenders registry. So there was, in fact, some logistics, some homework done. We would certainly need, as we move forward, because we have had implemented an e-register of going back to 2000 and ensuring that we list persons who have been convicted with respect to sexual offenses. Certainly, we'll need to have some training because we have designated officers, sergeants, and above, who certainly would have a role with respect to the responsibilities of this once this bill is passed. So we need some training as well as certainly some equipment, IT-type equipment and so on. But we would in fact certainly be able to execute the provisions and
Thank you very much. As we close, I want to thank the representatives from the Children's Authority, the Trinidad and Tobago Police Service, and the Trinidad and Tobago Prison Service for both your written submissions and your attendance before us this morning to expand and clarify on the areas that the members of the committee wished to engage your attention. As a follow-up, I know we've asked the Children's Authority to submit to us in writing your views on the matter raised by Member Ramdeen in relation to age. On Trinidad and Tobago Police Service, the matter raised by Member Batiste Primus on the data that you are currently going through, and you have indicated to us that March 8, 2019 is the date by which you can provide that information. And to all three entities, I invite you to continue. We have scheduled 3 further public hearings. I invite you to follow those proceedings. And if you believe that there is anything more you can provide to us in relation to the particular bill that would assist us, I welcome your written submissions. Thank you very much. This meeting is now adjourned to Friday, March 1st, 2019 at 10 a.m.